Good afternoon, everyone. Thank you for joining us for today's webinar on workers' compensation and COVID-19. I'm Adam Rossi from the Communication and Outreach Unit here at the Workers' Compensation Board. Today, we will discuss the basics of the workers' compensation system, as well as information to help workers who believe they contracted COVID-19 on the job, especially those who have missed time from work or are suffering from ongoing or long-haul symptoms. We ask that you please keep your phone lines muted, as we will be using the chat feature to receive your questions today. You can enter your questions throughout the presentation in the chat box, which is located on the right side of your screen. Just please use the drop-down to send your questions to all panelists. Some of our panelists are logged on remotely today, so they will not be able to see your questions unless you send your question to all panelists. We will answer as many of your questions as we can, but if you have questions that we don't get to today, or if you think of something after the session ends, we will be providing you with resources at the end of the presentation. Joining us today to assist with answering your questions, we have the board's General Counsel, David Wertheim, the board's Medical Director, Dr. James Tachi, Deputy General Counsel, Heather McMaster, and last but not least, our Advocate for Injured Workers, Joe Cavalcanti, who is going to say a few words to kick things off.
Thank you, Adam, and thank you everyone for joining us. The Office of the Advocate for Injured Workers here at the board exists to support the injured workers of New York State. We're here for you. So in today's presentation, we'll be sharing important information about workers' compensation for employees who have contracted or who do contract COVID-19 due to an exposure in their workplaces. As part of this, we will be detailing how and when to file a claim. And the when here is very important, and one of the key reasons we're doing this webinar today. Workers have 2 years from the time they contracted COVID-19 to file a claim. So if you believe you contracted COVID-19 in the workplace in October of 2020, you need to file a claim now. You will also learn what to include in your claim to show you had COVID and that your COVID-19 was work-related. I look forward to answering your questions at the end with the rest of our panel. So let's get started, and I'll turn this back over now to Adam.
All right, thank you, Joe. So let's get started. Let's take a look at today's agenda. We'll start by explaining what workers' compensation is and what your rights are if you become injured or ill on the job. Then we will discuss how workers' compensation can help those affected by work-related COVID-19, including workers who are facing ongoing or long-haul symptoms. We'll talk about the importance of filing a workers' compensation claim and walk you through the process of doing so, including the medical documentation that's needed to support your COVID-19 claim. Finally, we'll point you to some helpful resources for more information or assistance with filing, and again, we will leave time at the end to take any questions. So let's start with a brief overview of workers' compensation. Workers' compensation is a no-fault insurance system and is usually covered by insurance through an employer unless they're self-insured. We'll discuss this more a little later in the presentation. An employer cannot charge a worker for the cost of this insurance, and it provides medical care and lost wage benefits to workers who are injured or become ill on the job. An employee is considered anyone providing services to a for-profit business or any compensated individual providing services to a nonprofit organization, regardless of employer size. The only exceptions are clergy and some school teachers, although the vast majority of school teachers in New York State are voluntarily covered. There is no cost to the worker to receive the necessary medical treatment for a work-related injury or illness. This is a lifetime benefit unless a worker signs a settlement or a Section 32 agreement that closes any medical eligibility for a payment. This includes all medical expenses, such as tests, hospital visits, medications, physical therapy, equipment, and home care attendance. Transportation costs for travel to all medical appointments or treatments are also reimbursable for life, and there is no time limit to when a worker can file to have these costs reimbursed. Now let's discuss the workers' cash benefits, otherwise known as indemnity benefits. 2/3 of a worker's average weekly wage is payable while the worker is out on workers' compensation with 100% disability. This includes all compensation, so for example, tips, perks, etc. The maximum benefit is now $1,125.46 per week. This is based on New York State's average payroll and is recalculated every July 1st. Benefits in the workers' compensation system are temporary, except in the event of a permanent injury. In that case, the worker will be evaluated to determine whether they have a permanent total disability or a permanent partial disability. Finally, there are payments for a loss of use of a limb. This is known as the Schedule Loss of Use Award and may be eligible for injuries to the following: the arm, hand, fingers, leg, foot, toes, eyesight, hearing, or disfigurement. There's also a fatality benefit, which is payable in instances where a worker perishes due to an incident, consequences of a previous incident, or an illness, such as COVID-19, at work. With this benefit, funeral and memorial expenses are reimbursable up to $12,500 in the New York metro area and $10,500 throughout the rest of New York. Surviving family members are also entitled to weekly benefits, which are calculated the same way as the indemnity benefit. So it's 2/3 of the deceased worker's average weekly wage. Beneficiaries include the spouse of the worker, children up to the age of 18 or 23, and any disabled or blind dependents. If none of these parties exist, $50,000 is payable to the parents of the deceased worker. If there are no surviving family members, $50,000 will be paid to the estate. In terms of who pays workers' compensation claims, that depends. If your employer purchased an insurance policy, the insurance carrier who wrote the policy pays the benefits. If your employer is self-insured for workers' compensation, your employer pays the claims. Usually, self-insured employers use a claim administrator to handle claims, so you will be interacting with that claim administrator in that situation. That's known as a third-party administrator. When the employer does not have the required workers' compensation insurance coverage in place, the Workers' Compensation Board will pay the claims so workers can get the needed benefits. Then the board recoups the cost from the employer, along with any penalties for not having the insurance in the first place. Workers' compensation is a worker's legal right. If you are injured or become sick at work, you are entitled to workers' compensation. It cannot be negotiated or signed away. Also, immigration status is not a factor, and the board does offer free language assistance if you would like it. So, what is the role of the Workers' Compensation Board? The board administers and oversees the workers' compensation system. However, as previously mentioned, we do not typically pay the claims unless the employer has failed to provide proper workers' compensation coverage. We have approximately 1,000 employees across 26 offices and hearing points statewide. Our role is to ensure the system operates correctly by receiving reports of all injuries, payments, medical reports, and any other documents relevant to the claim. We will also hold hearings in front of an administrative law judge when appropriate to adjudicate or move a claim forward. So hopefully that gives you a high-level understanding of the workers' compensation system, your rights and benefits if you become injured or ill on the job, and the role of the board. Now let's discuss what you need to know and what actions you should take if you contract COVID-19 in the workplace. The very first thing to do when you are sick or injured on the job is to seek treatment. In an emergency, you can see any healthcare provider, but otherwise, please go to a provider who is authorized to treat injured workers by the board. You can find one using the provider search on our website at wcb.ny.gov. You can also visit your local New York State occupational health clinic for treatment from an authorized provider. You can search for your closest clinic on the Department of Health website, and that link is here on the slide. Tell the provider who treats you that you believe you contracted COVID-19 from an exposure at work. Share any details about your workplace to back that up. For example, how would you describe your workplace? Was there public contact? Were masks worn? Did your coworkers have COVID-19? That, and as well as any other circumstances the provider should know about for your potential exposure. If your healthcare provider agrees, they will send a medical report to the insurer and to the board. It is best if the medical report includes your positive COVID-19 test result, but a medical report showing a diagnosis via a PCR test or by virtue of examination may also be used. You will need to notify your employer in writing that you believe you contracted COVID-19 at work. An email or document is best. A text message can be accepted, but it's not recommended because sometimes they're not easy to find and duplicate if necessary. Notify your employer as soon as you can, but no later than 30 days of becoming ill. Your employer is then required to notify the workers' compensation insurer. Now let's take a look at how to file a COVID-19 workers' compensation claim. You should file a claim for workers' compensation. Workers are not required to file a claim because the insurance carrier must notify the board of the incident. However, filing your own claim is valuable protection and is extremely helpful, as I'll explain in a few minutes. As Joe had mentioned before we started, you have 2 years from the time you contracted COVID-19 to file your claim. So if you are approaching this deadline, you need to file your claim as soon as possible. The fastest way to file is the employee claim form, or the C3 form, which can be found online. You can visit the COVID-19 area of our website, and that link is right there on the slide. You can also file a paper form, which you can download from our website. Just follow the instructions on the form for submitting it to the board. And we would like to note that the Form C3 you fill out is the same form used for any injury or illness experienced on the job. It is not specific to COVID-19. If you have any questions while you're filling it out, please do not hesitate to contact us, and we will be giving you our contact information later on in this presentation. If you have a PCR test result showing you had COVID-19, file that report. That's very important to your claim. If you had COVID-19 earlier in the pandemic and you got your results by phone, as many people did, you should now get that result in writing and file that. So what do you need to share in your claim to show that your COVID-19 illness is work-related? Most workers cannot point to the exact moment or method of exposure to COVID-19. However, you can demonstrate a high risk in your workplace if you work in an environment where exposure to COVID-19 is or was prevalent. For example, a hospital, a transportation job, grocery store, or anywhere else. On the claim form, include details about where you work, how often you work, and your job duties, especially those involving public contact. Section D of the claim form has space for you to share any relevant details. While not all claims will be accepted, there is no harm or risk in filing the claim, even if it ends up getting denied. Filing a claim is important for anyone who believes they contracted COVID-19 at their job, and especially those who are missing work or experiencing ongoing symptoms, as there may be benefits that can help you right away. If you are experiencing long-haul medical issues due to work-related COVID-19, you may be eligible for free lifetime medical care. If you miss more than 7 days of work due to work-related COVID-19, you may be eligible to receive lost wage benefits. This may be very helpful to long-haul sufferers who regularly miss time from work due to medical appointments or worsening symptoms. For anyone who contracted COVID-19 on the job, whether or not you had access and used paid sick time, whether or not you've since recovered, it is important to have an established claim, a record that your COVID-19 was work-related, should you suffer long-haul complications and need workers' compensation benefits down the line. If you already have an established claim for COVID-19, any lost wage benefits or ongoing medical care that is directly or consequently related to COVID-19 falls under that existing claim. So, for example, someone with an established COVID-19 claim may also need ongoing treatment for problems from the COVID-19 related to their kidneys or lungs, or they may develop consequential conditions such as anxiety or depression. If you need help filing a claim, you can call our toll-free customer support line shown here on the screen at 877-632-4996. And again, free language assistance is also available should you need it. If you face resistance or obstacles to getting information about the claims process, or if you're discouraged from filing a claim, please let us know. We will help you. Email our Advocate for Injured Workers at advocateforinjuredworkers@wcb.ny.gov. So what happens once you file? If the insurer accepts or agrees with the claim, it will be payable, and this is known as compensable. If the insurer disputes the claim, a judge at the board will decide whether the claim should be paid. Right now, everyone has to attend our hearings remotely because our offices are closed to the public. While the attorneys must attend by video, injured workers have the choice to either participate by telephone or by video through our virtual hearing center. Your hearing notice will contain all the details. The judge may hear testimony to get the facts about where you work, whether you were exposed to COVID-19, the extent of exposure, and whether exposure to COVID-19 was prevalent in your work environment. Remember, you do not need to pinpoint a moment in time when you think you were exposed. We review all the facts in the claim. From there, it is possible to appeal a judge's decision, and we have an appeal process if that happens. Now, let's take a look at the additional resources that are available to you. For more information related to COVID-19, including quick links for finding an authorized workers' compensation provider and for filing a claim, please visit wcb.ny.gov/COVID-19. On that page, you'll also find numerous resources such as fact sheets, frequently asked questions, and more. You can also subscribe for email updates related to COVID-19 and workers' compensation by selecting the Subscribe for Updates button on the top of the page. For other helpful information for workers on workers' compensation and other topics, you can visit the Workers page on the board's website at wcb.ny.gov. Finally, our Advocate for Injured Workers is also at the ready to help injured workers who are having difficulties with their claims or trouble accessing their benefits. You can contact the Advocate's office by calling 877-632-4996, or you can email advocateforinjuredworkers@wcb.ny.gov. We also have a very active social media presence to help you stay informed on workers' compensation topics and for the latest news from the board. Please be sure to follow us on our social media channels to learn more about future webinars like this one, as well as information on webinars on New York State's paid family leave benefit. You can see our Twitter, Facebook, Instagram, and YouTube handles here on the screen. Thank you again for attending this presentation on COVID-19 and workers' compensation. We hope you found this information helpful, and we will now take the rest of your time to answer any questions you may have. Again, please keep your phone lines muted. We are using the chat feature to answer your questions. When you're entering your questions, just make sure the drop-down is sending the questions to all panelists, as we do have panelists who are remote and cannot see questions that are only sent to the host. So please keep that in mind. There may be some brief periods of silence as we review the questions that have come in. And I do see that we have a few questions that have come in already, so we will be back with you shortly as we review those.
We have one question here as to whether or not the COVID paid sick leave law is still in effect. It's a 5-day sick leave rule. That law is administered by the Department of Labor, but to the best of our knowledge, it is still in effect, and it is still the law of the state.
The question is next, can you explain workers' comp in regards to death from COVID-19 at the workplace? There is a fatality benefit in the workers' comp system. So that would include any incident, that results in a worker's death, including COVID. You're going to file a fatality claim, and if this is something that's happened to a family member of yours, or you're the executor of an estate for someone who passed away due to COVID that you believe was contracted at work, would you please contact my office, because we are here to help people in particular with this process. So yes, there is a fatality benefit in the workers' comp system, and yes, it does pertain to COVID as well.
There's a question, how do you prove that you got COVID at work? So first and foremost, if you are experiencing symptoms, you would contact your physician or healthcare provider. They will likely order a COVID PCR or laboratory test, which is the gold standard for demonstrating the diagnosis of COVID. And then you will talk with your physician or provider about what your job is and what your workplace exposures may have been to COVID. And based on that conversation between you and your provider, you will determine, or your provider will determine, whether or not they think that your COVID is related to the workplace. And then they and you will submit the documentation accordingly.
If COVID is determined work-related, how do we put that on the OSHA log? I'm terribly sorry, but the OSHA log is a federal document, and we're the state system, so you would really have to contact OSHA or use your federal resources for that. We're not going to be an authority on that. There's another question regarding who determines if COVID-19 exposure is work-related. Well, ultimately, it would be the board. If the insurance company and the worker do not agree on the COVID exposure and where it happened, that's going to come to the board, and the board will make the final decision there. You might have some hearings in front of a law judge, but that's what we do here at the board. All right, maybe it's a common question. It's a little detailed, and it has a simple answer. Here we go. If the employer has a company that administers workers' comp, should they file the claim through that company in addition to directing the employee to complete the employee claim form on the website? Okay, let me simplify this for you. This is from the worker's point of view. You have a work-related incident, be it COVID or be it anything else. Tell your employer about the incident. Tell your employer about the incident. because they have requirements wherein they have to tell their insurance company and things have to get filed with the board, otherwise penalties can result. So the employers want to know, and the insurance carriers definitely want to know that there was an incident. That's good for a worker because that gets the claim started. Now, the worker can, in addition, file a C3 form with the board, okay? That's the worker's accounting to the board that there was an incident, and we discussed how to do that during the presentation. That's what you need to know. That's the process. If there's a company that's administering workers' comp, like a third-party administrator as they're known, Adam was explaining that they handle the claims for the employer. That's not anything that the worker needs to really be concerned about when there's an incident. Tell your employer, file a C3. Those are your big steps.
There's a question, can an employee file a COVID-19 claim if they do not have a positive COVID test? I assume that by that question you mean that you don't have a positive laboratory PCR test. So as we mentioned before, the laboratory PCR test is considered the gold standard for establishing the diagnosis of COVID. So patients and claimants should get the testing done whenever possible and feasible. There may be circumstances where you're not able to get one done. It does not mean that you can't file a claim, but it just means that you won't have that piece of documentation as part of your claim. The nice part about the PCR tests is that they are date and time stamped and individual to you. It's documented, with your name and date of birth, etc. So anyone can look at it and see whose test it was and when you were diagnosed with COVID. The home testing do not have any identification on them. They are not date and time stamped as to when the tests were taken, and they're not as accurate. So you're not precluded from filing a claim, but you and your physician would not have that gold standard piece of documentation to include with your claim to be evaluated by the insurance company and the law judge.
Another question on filing. If the employee files the C3 form, is the company notified somehow that they filed it? Well, the answer is going to be yes, because your employer, the company, your employer is a party of interest to the claim. That's the technical term, party of interest. You're a party of interest, your employer is a party of interest, the insurance payer is a party of interest. So yes, they will know about the filing of the C3 because it's going to begin your claim, and the employer is copied on the documentation that the board creates regarding each claim.
So there's a question, how are mental health conditions covered related to COVID? So if a mental health condition is deemed causally related to your COVID infection, it will be covered just like any other workers' compensation injury or illness. By way of perhaps a simpler example, if I were to break my ankle, requiring me to be in a cast and to use crutches, and because of the cast, I developed knee problems in the same leg or hip problems in the same leg, then either I or my lawyer can say that they believe my knee and hip problems are causally related to the ankle, right? And that they should be included and they're consequentially included in my workers' comp claim. Similarly, if you and your healthcare provider believe that your mental health conditions are specifically related to your COVID infection, then you would pose that, and it would be determined whether or not they are. And if it's determined that they are, then they're treated just like any other condition under the comp system.
I see a question that just came in about asking if we're going to have resources for this presentation. Yes, we will have if you go on our website now, there's a copy of this slide deck as well as a previously recorded version, and we will be offering a updated recorded version of this as well. Please make sure you're subscribed to email updates so you know when those are available. Again, just go to our website, wcb.ny.gov. Scroll down to the bottom of the homepage, select Get WCB Notifications, and you can choose which topics you'd like to subscribe to. We also have a subscribe for updates button on our COVID-19 specific page, so you can sign up to just receive COVID-19 updates, as well as when this webinar recording will be available to the public.
Also on our website, I don't know if everyone realizes, we have dozens of publications about workers' compensation. If you go to the bottom of the web page and you'll see a big green bar, there'll be a link for publications. I would really encourage everyone who's new to the system, or maybe those who've been in here a while, to look at the publications, because we have them broken down by category of interest. For example, workers and then employers. But we really have spent a lot of time and energy on creating these publications, and they really do provide pretty brief, tight, informative descriptions of the system, of the benefits, and of the processes. So I'd just like to bring that to everyone's attention.
There's a question. How does the board determine if other illnesses are a result of COVID? Is this based on medical evidence? Similar to the prior question related to mental health conditions, and just like the answer with respect to a broken ankle, right? If you have a condition and it's established as work-related, and then you think that there's another illness or condition that might be related, in this instance, to COVID, then your doctor would state that they think, just like, again, going back to my example, if I had a broken ankle and my doctor thought that my knee problems were the result of having to wear a cast on my ankle, my doctor would state, I think that that this patient's knee problems are the result of his broken ankle. And then the insurance carrier and their physician will either agree and say, yes, we agree that the knee is related to the ankle. And if they don't, then you and your representative or your attorney can bring that to the board. And the board, typically a workers' comp law judge, will weigh the medical evidence on both sides and help decide whether or not the knee or any related condition is related to the broken ankle. And it works the same with other illnesses and COVID.
We have a very big picture question now. Does every state have their own workers' comp board and process? The answer is yes. Workers' compensation in the United States is state by state. So the processes and benefits available in the New York system, they're going to differ from every other state's system. There are actually 51 jurisdictions in America, to be technically correct, because you have the 50 states, and then the District of Columbia also has its own system. And another thing to note is that federal government employees, regardless of which state you're working in or living in, federal government employees are part of the federal workers' compensation system. Here's another question, another very big picture question. If someone is receiving disability benefits through the Social Security Administration, so SSDI as that is known, and their employer does not allow them to take time off and this and that, is the condition and it gets worse, is that a workers' comp claim? Well, there's a very basic question here. Is the worker suffering from a work-related injury or illness? If the answer is no, then no, this is not workers' compensation. It's SSDI for other reasons. So you're only coming into the workers' compensation system in New York State if you have an injury or an illness or, God forbid, a fatality due to your employment. We have a question about masking at work, wearing masks, not wearing masks. Let's just bring it down to the most pertinent point. Did someone get COVID due to employment? That's the important factor here in this system and in workers' compensation. Whatever you can point to indicate an elevated risk of exposure. Okay, we talked about that earlier. But that's what's the basic thing here. That's what you have to keep in mind. Did someone get COVID-19 due to employment?
All right, thank you, Joe. Again, that seems to be all the questions we have, so we're going to go ahead and wrap up. Thank you, everyone, for joining us today. Thank you to all our subject matter experts who were on hand to answer your questions. Just want to remind you before we go that more information related to COVID-19, including quick links for finding an authorized workers' compensation provider and for filing a claim, can be found at wcb.ny.gov/COVID-19. Again, you can also subscribe for email updates related to COVID-19 and workers' compensation by selecting the Subscribe for Updates button at the top of the page. To receive other workers' compensation news, including information on future webinars, visit wcb.ny.gov, scroll down to the bottom of the homepage, and select Get WCB Notifications. For other helpful information for workers, you can visit our workers page on the board's website. Again, that link is wcb.ny.gov. And just to reiterate, I saw someone else signed in late and was asking, a recorded version of this presentation will be available on our website and YouTube page. So just make sure you're subscribed for email updates so you're aware when those are available. And speaking of YouTube, please be sure to follow us on our social media channels. Again, Facebook, Twitter, and Instagram, as well as our YouTube page. Thank you again for joining us, and enjoy the rest of your afternoon.